State of Wisconsin versus Joel Manke, 23 CF 3130, appearances.
Mallory Davis appears for the state. Seated with me is the lead investigator on this case, Detective James Pittman.
Good morning, Your Honor. Mr. Manke appears in person by counsel Jacob Mannion.
And good morning, everyone. We're here today for plea and sentencing. Are parties ready to proceed in that fashion? State?
Yes,
Defense?
Yes, Judge.
State, you have notice for plea and sentencing today.
we do.
What are the negotiations, please?
Mr. Manke will plead to counts 7 and 8 in the state's complaint, both chronic neglect of a child, consequences, emotional damage. The state will move to dismiss and read in the remaining counts. State will recommend sentence to the court.
Counsel, is that your understanding of the plea negotiations?
It is, Judge.
And good morning, Mr. Manke. How are you?
I'm doing well, thank you.
You've heard what the lawyers have said about what the plea negotiations are. Is that your understanding, sir?
Yes, it is.
That is, you would plead guilty to counts 7 and 8 contained in the information. Chronic neglect of a child, consequences, emotional damage. The remaining 2 counts of false imprisonment would be dismissed but read in for sentencing. And at sentencing, the state would leave sentence to the court. Your lawyer is free to argue for whatever you and he deem appropriate. Is that your understanding?
Yes, it is.
Very good. Let's talk about the charges you're pleading guilty to this morning. I'll start with count 7 of the information, chronic neglect of a child, consequences, emotional damage. And that between July 13th, 2022 and July 13th, 2023 at 128 South 71st Street in the city and county of Milwaukee, Wisconsin, that you, being a person responsible for the welfare of a child, CJJ, date of birth April 30th, 2014, through your action for reasons other than poverty, did negligently fail to provide necessary care so as to seriously endanger the physical, mental, or emotional health of the child, and the child suffered emotional damage as a consequence, and you are guilty of chronic neglect as you committed 3 or more violations of child neglect within a specified period of time involving the same child. That is that 1-year period from July 13th, 2022 to July 13th, 2023. All of this contrary to Wisconsin statute. You understand, correct?
Yes,
And you know that is a Class E felony for which you may be fined not more than $50,000 or imprisoned for not more than 15 years or both, correct?
correct.
Count 8 of the information, chronic neglect of a child, consequence is emotional damage, in that between July 13th, 2022 and July 13th, 2023 at 128 South 71st Street in the city and county of Milwaukee, Wisconsin, that you, being a person responsible for the welfare of a child, DMJ, date of birth September 24th, 2015, through your action for reasons other than poverty, did negligently fail to provide necessary care so as to seriously endanger the physical, mental, or emotional health of the child, and the child suffered emotional damage as a consequence, and you are guilty of chronic neglect as you committed 3 or more violations of child neglect within the specified period of time involving the same child, that is July 13th, 2022 through July 13th, 2023, all contrary to Wisconsin statute. That is your understanding, correct?
Yes,
You know that is a Class E felony for which you may be fined not more than $50,000 or imprisoned for not more than 15 years or both, correct?
correct.
Sir, do you understand that if you were to be sentenced to prison in this action, that you would have to serve in prison each day imposed as initial confinement time by the judge, because initial confinement time is not reduced by good time or parole?
Yes,
Part of the plea negotiations are that counts 9 and 10, both false imprisonment, would be dismissed but read in for sentencing, and you've talked with your lawyer about what that means, right?
yes,
You understand the court may consider those read-in charges when imposing sentence, but that the maximum possible penalty of the charged offense would not be increased, correct?
yes,
You understand you could be required to pay restitution as it relates to those read-in charges, right?
correct.
And you understand that the state of Wisconsin is prohibited from future prosecution of the read-in charges, correct?
Correct.
Understanding all of that, do you agree count 9, false imprisonment, and count 10, false imprisonment, may be dismissed but read in for the purpose of sentencing, sir.
Yes, I do.
Understanding everything that we've discussed, Mr. Manke, what is your plea to count 7, chronic neglect of a child, consequences, emotional damage?
Guilty.
What is your plea to count 8, chronic neglect of a child, consequences, emotional damage?
Guilty.
I have before me plea paperwork that your lawyer has filed entitled the Plea Questionnaire Waiver of Rights Form and the addendum to the Plea Questionnaire Waiver of Rights Form. These documents appear to be signed and dated by you and your lawyer on April 4th of this year. Did you sign these forms, sir?
Yes, I did.
Did you go over them with your lawyer before you signed them?
Yes, I did.
So you understand everything on the forms, is that accurate?
That is correct.
Your answers to the questions on the forms and the information provided here, that's all true and correct, right?
Yes, it is.
At the time you signed the form, sir, did you understand that you would be giving up the rights set forth on the forms by pleading guilty?
Yes.
In particular, when you plead guilty, you give up a variety of trial rights. Those rights do include your right to remain silent and not incriminate yourself at a trial, your right to see and cross-examine the state's witnesses, your right to call witnesses and make them come to court and testify for you, your right to testify at a trial, your right to have your case decided by 12 people sitting as a jury who would all have to agree in order to reach a verdict, your right to have your case decided after a trial to the court, and your right to make the state prove you guilty by evidence beyond a reasonable doubt that you committed the crime charged. You understand you're giving up those trial rights by pleading guilty, correct?
Yes, I do.
In order for you to be found guilty, it must be shown that you've committed acts that constitute the elements of the offense charged. To that end, your lawyer has filed the jury instruction 2151 for chronic neglect of a child, repeated acts of neglect. I see on there at least one part is highlighted. Did your lawyer review this jury instruction with you?
Yes.
All right. And in doing so, was he able to fully explain the elements of chronic neglect of a child, repeated acts of neglect?
Yes.
In reviewing this with you, sir, did your lawyer also go over with you jury instruction 2150 that outlines the different elements of child neglect that the state would have to establish happened on 3 or more occasions?
Yes.
Okay. And in doing so, was he able to fully explain to you those elements under Wisconsin jury instruction 2150, answer any questions that you might have about that?
Yes.
All right. And in your conversations with your lawyer, was he able to fully explain how that jury instruction 2150 works along with jury instruction 2151 as it relates to the chronic nature of these events?
Yes.
All right. And so he was able to answer any questions that you might have and fully explain how that would work during the course of a trial?
Yes.
Very good. I see here from the plea paperwork also that you've read the complaint. I presume you've discussed it with your lawyer leading up to today. You understand what the criminal complaint says happened, fair?
Correct.
Are the facts as contained in the criminal complaint substantially true and correct, sir?
Yes.
Based on your reading and review of that criminal complaint and your conversations with your lawyer about it, based on your review of the jury instructions that we've talked about, those elements it is that the state would have to prove at a trial, and your conversations with your lawyer about how that would work, do you believe, Mr. Manke, that you understand everything it is that the state would have to prove or establish if we did have a trial?
Yes.
Very good. Sir, you understand the court is not bound by plea negotiations or by anything recommended by anyone at sentencing, correct?
Correct.
You understand the court is free to sentence up to the maximum possible penalties provided by law, correct?
Yes.
Has anyone, including your lawyer, made any threats or in any way forced you to plead guilty today?
No.
Outside of the plea negotiations in this matter, has anyone, including your lawyer, made any promises to you to get you to plead guilty?
No.
Are you entering your plea freely, voluntarily, intelligently, and understandingly after having consulted with your lawyer?
I am.
I see from the plea paperwork that you are taking medications that are, I assume, and tell me if I'm wrong, that these medications are prescribed to you by a doctor or a treatment team.
Yes, they are.
Are you taking those medications as prescribed?
Yes, I am.
Is there anything about the medications that you're prescribed or the things that they are prescribed for that would interfere with your ability to understand what's happening here in court?
No,
Anything at all about your physical, emotional, or mental health that would interfere with your ability to understand what's happening in court?
no,
And you've not had any other drugs or alcohol within the past 24 hours outside of those that are prescribed to you, fair?
correct.
All right, very good. Sir, do you understand that if you are convicted of a felony, that you will be prohibited from possessing a firearm in the future and prohibited from voting until your civil rights are restored?
Yes,
Do you further understand that if you are not a citizen of the United States of America, that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law?
yes,
Have you had enough time to go over this case with your lawyer, sir?
yes, I have.
Has your lawyer talked with you about what he believes are potential defenses to the charges?
Yes,
Has your lawyer discussed with you what he believes are mitigating circumstances or good facts that he could argue on your behalf if we did have a trial?
yes,
Are you satisfied that you have sufficiently discussed with your lawyer and that you understand the nature of the allegations against you, sir?
yes, I am.
Are you satisfied that you have sufficiently discussed with your lawyer and that you understand those potential defenses and mitigating circumstances that may exist?
Yes,
Are you satisfied with your lawyer and the representation provided to you?
I am.
Are you at all confused about anything you're doing here today?
No,
Is there anything about the plea procedure that you do not understand or questions you have for the court about the plea?
no,
And are you pleading guilty in this matter to 2 separate counts of chronic neglect of a child? Consequence is emotional damage because you are guilty of that.
yes,
Thank you, Mr. Manke. Counsel, please, have you gone over the guilty plea questionnaire, waiver of rights form, and addendum with your client?
Yes, I have, Judge.
Did you go over the elements of the offense with your client?
Yes.
Are you satisfied that your client understands the elements of the offense and interrelationship between conduct and elements?
Yes.
Have you gone over the maximum possible penalties with your client?
Yes, I have.
Are you satisfied that your client understands them?
Yes.
Have you gone over all potential defenses with your client?
Yes.
Have you gone over all mitigating circumstances with respect to these charges with your client?
I have.
Are you satisfied that your client understands those potential defenses and mitigating circumstances that may exist in this case?
Yes.
Are you satisfied that your client understands all of the rights that he is giving up by entering his plea?
Yes.
And are you satisfied the plea is made freely, voluntarily, intelligently, and understandingly by your client?
I am.
Does the state consent to the jury waiver?
Yes.
This court approves the waiver and finds that Mr. Manke is entering the plea freely, voluntarily, intelligently, and with a full understanding of the nature of the charges, the maximum possible penalties, and all of the rights being given up by pleading guilty, and the court will accept the plea. May I use the facts in the complaint to support the plea? State?
Yes.
Defense?
Yes.
Mr. Manke?
yes,
Very good. The court finds that there is a factual basis for the acceptance of your plea, sir, and based on your plea of guilty, the court now finds you guilty of the offense of chronic neglect of a child, consequences emotional damage, and chronic neglect of a child, consequence is emotional damage, in the manner and form as charged in the information. I adjudge you convicted on this date. I order a judgment of conviction entered in the record. Pursuant to negotiation of parties, counts 9 and 10, both false imprisonment, are dismissed but read in for the purpose of sentencing. Are the parties ready to proceed with sentencing then? State?
Yes.
Defense?
Yes.
Mr. Manke, may we move forward with sentencing you at this time?
yes,
Very good. State, is there a written victim impact statement or request for restitution that has been received by your office?
No.
Counsel, I have received and reviewed documents 78, 79, 80, and 81. Are there other documents defenses filed for sentencing here today that I may have missed or disregarded?
No, Your Honor, thank you.
Very good. State, I'll hear your presentation.
Thank you. Mr. Manke's criminal history is a 2014 possession of an illegally obtained prescription, a 2014 OWI, and a 2015 out-of-state OWI for which he served 3 months. This case, I know that the court is very familiar with a lot of the body-worn camera of this case, and I won't be showing anything the court has seen in suppression hearings or in previous sentencings. So the Milwaukee Police Department in July of 2023 received about half a dozen separate 911 calls. All believed that DJ was a girl due to the long hair that was matted with feces and dirt. Callers also stated that the children had red marks on their bodies, believing at the time that they had been abused based on what they were seeing. The court should be aware of the immediate community impact this had. It was a July afternoon. The kids were outside playing. People in the neighborhood were having a very normal day. It's a neighborhood that reminded me of where I grew up. There were just kids running around everywhere. There were some parents sitting outside on their porch, enjoying the day. And it's a street full of kids who probably would have loved to have 2 more kids playing with them all summer long. There are additional interviews from the neighbors detailed in the complaint, indicating all similar stories, but from their own point of view, including a 13-year-old child, TP, who observed what he said was a 12 to 13-year-old girl sitting naked on the southwest sidewalk outside of 138 North 71st Street while he was outside playing. TP stated he wasn't sure if it was a boy or girl, but they looked to be about 12 or 13 years old with long hair. TP stated the naked person was walking on the sidewalk like a caveman. TP stated he and the other neighbors pointed to firefighters that were on scene where to find the naked child. TP said his grandma, CJP, went to speak with a woman who looked off, and the woman kept asking CJP, "Where's my kids?" TP then observed another child in front of 123 South 71st Street. One of the neighbors was afraid this was a sex trafficking situation based on what he saw, where these kids were being abused and trapped inside of the home. The most important thing about the interviews with neighbors is that none of them reported seeing the children outside of the residence before. A majority reported that they had never seen the children outside, but one neighbor said that he saw them outside in the yard when they moved in approximately 3 years prior, but he had not seen them since then. The neighbor indicated he complained to Katie, the co-actor, about boarding up the windows because he believed it was wrong. Officers responded and entered the home. The co-actor, Katie, initially blames the children for barricading the door and says that they broke the window, so now they're going to have to board the window up. Katie, when asked by officers what was on the wall, says it's clay, paint, and chocolate. She showed that she's very aware of an issue and then blamed the children for what was happening and minimized the situation at the time. Mr. Manke arrived home from work. DJ can be seen on body-worn camera. This court has reviewed multiple times, clinging on to Mr. Manke and calling him dad. Officers conducted a tour of the kids' room. I did provide the court with photographs just as a reminder. They are separated into groups of the kids' room, the co-actor's bedroom, the kitchen area, and then photos of CJ and DJ on the day that they were recovered. When conducting a tour of the kids' room, it's immediately observable that there's feces covering the wall, including full pieces of fecal matter, not just streaks of it being wiped on the walls. There's fecal matter covering the ceilings, active insect activity throughout the room. A live mouse runs out from under a mattress in the room while officers are in there. Detective Pittman indicated that the mattress felt damp, even though he was wearing multiple layers of gloves. There is no indication of whether it's urine or other moisture. The windows had been soundproofed and boarded up. There were shards of glass on the floor. Not a single inch of the floor was cleared for walking. The door latches from the outside confining the children into the room. There was also a doorknob cover so that the children couldn't turn the doorknob themselves. Detective Pittman did bring up the lack of circulation of air in the room. The windows are boarded up. The room is full of feces. The mattress is likely soaked with urine, with insects and rodents, what these poor children must have been breathing in so consistently, with no breaks for fresh air. It should be noticed that cleanliness in the house could be found in one room. The bathroom of the residence was absolutely immaculate. Officer Marks transported and monitored the children and stated they exhibited several attention problems and were fascinated by everything they saw in both the ambulance and at the hospital. He stated the interactions with others and between themselves were as though they had never been outside of a house. Officers spoke to both co-actors. The 2 boys in the home are the children of Katie's, but Mr. Manke assisted in the cares of the children. He indicated he had done so for the last 3.5 to 4 years. Mr. Manke told officers at one point that he put up the boards so that the kids wouldn't bother the neighbors, and admitted that Katie uses the latch on the door to keep the kids locked in the room, to keep them from wandering, and blamed it on the kids' autism. Mr. Manke stated that in the 3 years or so that Katie and the kids had lived with him, he had never seen Katie take the kids for any kind of medical, and that the kids had not been in school for that period of time. An interview with Katie stated that she and her children had been residing with Mr. Manke at the residence for approximately 4 years. Katie stated that the kids call Manke dad. Katie stated that both kids have never been enrolled in school and that she homeschools them. Katie says that she fucked up. Katie says she doesn't want the boys to lose the stability that they currently have. It had been a year or two since the kids had been provided medical. Katie admitted that kids deserve better. Katie admitted that the children couldn't read or write, but that they have educational apps on their tablet, and that at that time, DJ could trace small letters. Katie admitted the lock on the outside of the boys' room door had been there for a number of years. She stated that the feces on the wall wasn't just feces, and that it had been there for a while now. Koch stated that was informed the children had to be shaved at the hospital because of how matted their hair was with fecal matter. And Katie said that was okay because they needed a haircut. Katie said the last time the boys had been bathed was on Sunday, which was 5 days prior, and that it is her job to bathe the boys. But maybe the bathing wasn't as thorough as it should have been. At the time of the interview, Katie said that she was diagnosed as OCD and bipolar, but she was clear that her mental health was not an excuse. During Mr. Manke's interview, I found it very interesting that there was an inference that the boys' door needed to be latched for the boys' safety, but Mr. Manke says verbatim in his QP, "I got a call from Katie. She was panicking because the boys got out of the house, and she said they broke a window and got out, and they've never done anything like that before. They don't try to leave. They don't, try to mess with doors or anything like that." Mr. Manke says the kids call him dad. He was the sole provider for the family financially, outside of some child support provided by the boys' biological father. Mr. Manke says that he helps with some of the day-to-day tasks for the kids, like getting them dressed, haircuts, etc. Mr. Manke says that not only do the boys consider him their dad, but they consider his parents their grandparents. Mr. Manke talks about how he comes from a supportive family who continues to support him to this day. Mr. Manke talks about how much more supportive his parents are than Katie's, and he called the difference in their parents and the support they receive night and day. Mr. Manke says that he cleans the bathroom and that Katie is in charge of the laundry. Mr. Manke says he hasn't done laundry in years. Mr. Manke says that the windows had blankets on them because the boys were staring at a neighbor and the neighbor was complaining. When pushed and asked why the windows were boarded up, Mr. Manke said that the windows broke and he didn't have the glass to fix them. It should be noted that 1, there was fresh broken glass located on the day of the incident, indicating the window had just been broken. 2, there was a second window boarded up that was not broken at all. 3, the neighbor actually spoke to police and indicated that he had complained to the family about having the windows boarded up because he didn't think it was right. Manke continued to insist that even the window facing the family's own garage needed to be boarded up to prevent the boys from looking at the neighbor. When questioned why there were forms of soundproofing, like a cookie pan and a mattress pad, in between the boards and the windows, Mr. Manke denied knowing they were there, despite indicating he was the one that boarded up the windows. Detective Pittman also noted in conversations, it was not only admitted that Manke had boarded up the windows, but the way that they were boarded up appeared to be done by someone who had worked at minimum in a handyman capacity prior. There were washers installed under each of the nuts and bolts, and everything was even and level. Mr. Manke said he hadn't been in the boys' room for a few weeks, but said that Katie would go in and make the boys' bed, which is an odd statement to say about that room, as if the bed could even possibly be made in its condition. When asked about the boys, specifically DJ not being potty trained, Mr. Manke said that he had to pick his battles, a phrase he used prior when talking about the cleanliness of the house and the boys not being in school or going to the doctor. In his constant minimizing, Mr. Manke tells Detective Pittman that the substance on the walls is food. When pressed and told it's clearly feces, Mr. Manke acts surprised and says, "Is it?" Mr. Manke says the boys spend a fair amount of time in there watching TV and playing on their tablets and, quote, sitting on their beds. Mr. Manke says the knob cover was put there because the boys would have meltdowns and try and get out of the room. Mr. Manke says he thinks Katie put that on there. Mr. Manke also admits that the latch has come out of the door multiple times and that they had to re-put the latch back on those multiple times so that it could still be locked from the outside. Mr. Manke continues to say that the kids don't go outside because of the neighbor. It is strange how much blame Mr. Manke puts on this neighbor for the situation the boys are in. Mr. Manke admits that he did not grow up like this, that it's not safe for the boys to live this way, and that he could have remedied the situation by cleaning up. Mr. Manke denies that either he or Katie used the latch, but doesn't explain why he would keep reinstalling the latch after saying it's come out multiple times. He does go as far as to say that there was still a latch there previously, saying it's come out multiple times and that he had to re-put it back in. So who are the kids here? CJ with a date of birth of 4/30/14 and DJ, date of birth 9/24/15. At the time they were removed from the house, neither child was potty trained, neither could read or write, neither had been to school in at least 3 years. Medical noted, CJ and DJ were found by neighbors walking along the street naked. It was discovered that the boys had escaped from a window in the home. They had been held captive, locked in a bedroom for several years. The home was found to be uninhabitable, with feces smeared on the walls and floors. The children are mostly nonverbal and do not attend school. Forensic interviews were attempted, but the boys were not okay with the door shutting and mostly just screamed until they were permitted to leave the room. The medical examinations had to occur in a waiting room because they were unable to get the boys into an examination room. The boys were noted as hyperactive and minimally verbal, difficult to examine. They were unable to have a completed full skin assessment. Both boys had standard bruising for their age, nothing to indicate any physical abuse. There is blood noted, particularly on CJ in the photos provided, likely from climbing through the glass shards of the window. The medical visit was important. The boys are unable to attend a medical appointment with having a complete breakdown. They weren't even able at that time to make it into the exam room. The boys were so far removed from society that they were almost non-functioning at the time of this incident. The boys weren't potty trained, and initially they bounced foster homes for a while because there were not many placements that could handle 2 grown children who are not potty trained and were so minimally functioning based on having little to no contact with the outside world for so long because of their complete lack of education. There are multiple allegations from defendants that the boys are autistic. They have made a formal diagnosis at this point, but it's difficult to determine where on the spectrum the boys should be based on the conditions that they grew up in. The boys were behind on their immunizations. The defendant, Katie said they could read and write small words, but that did not appear to be true once they were actually evaluated. They were unable to determine initially what grade level the boys should even be at. The boys had their heads shaved, as I said previously, due to the amount of feces that was matted up in their hair. They were finally placed with a foster mom that employs a fully trained staff. She cares for all kinds of kids. She has a child in her home with Angelman syndrome. She has a survivor of abusive head trauma who is fairly non-functioning, and then kids with higher needs like CJ and DJ. She described the boys when they first arrived as defiant, impulsive, needing locks outside on the door and the gate in the yard, hyper-focused on food and drink. You had to keep a close eye on any other people around them. They would eat out of the garbage and drink out of the sink. They would spend hours at a time screaming. They would cause damage to the yard, and they would sit and peel paint off of the side of the house. They would kick at the doors. There was a lot of anxiety for DJ specifically, wanting to go inside when he was outside. They lacked large and fine motor skills. They were peeing and having bowel movements on the floor. Right when we got to the house, I remember the foster mom, because we did get to go visit them, and I do have a video for the court. But the foster mom described the first day they got there, the boys were like standing on the couch and just screaming and having defecating and peeing on the furniture. And that was her first day when the boys came into the house. They struggled with sleeping and they needed multiple people watching them at a time, including regular overnight checks. They had repetitive language. They repeated, "I'm lost," and "Where's my mom?" They struggled to take the boys out into the community at all. So as of October 2023, the update was that they were settled in knowing the routine. They were using the toilet more regularly. They were starting to listen and follow directions. They were more acquainted to the rules, routine of the home. When they were upset at that time, their meltdowns only lasted about an hour. They were doing well in school. They really liked going to the McDonald's play place and going on walks. There were less attempts to leave the house and the yard. They were able to sit and play more independently, and they were beginning to bond to the caregivers. Detective Pittman and I went at the end of January. The caregivers were all very excited. I should have brought their schoolwork, but their foster mother gave me some of their schoolwork where they were writing out words on their own. So they are capable of writing and reading now. They spend the entire day in school, and they're able to stay in school that full day. The caregivers couldn't wait to show me videos of them sitting through their first movie, and they were able to sit through the movies at the movie theater now with some popcorn. They got to go to an amusement park, and they were able to do that. They can go into the store now and each pick out a single piece of candy, and that's okay. They know limits. So the boys are able to be in society now. And it'll be 2 years in July, and every day still has its own struggles, but the boys are doing much better now. The caregivers have given up a lot to make sure that these boys can start acclimating back into society, but they've done a really great job. So I just wanted to show the court a very short clip of the boys. Now. So this video was provided in discovery to defense. It's called Interview with Ramona Mosley, 2025, Part 3. I'm starting at 30 seconds.
Hi, Chase.
It's wonderful to meet you.
I'm James. Pleasure to meet you, sir.
Mimi, you would come up?
What's the matter? Because she found herself.
Oh, yes, right. Now, did you apologize to the house?
Yes.
Don't tell everybody you're sorry.
I'm sorry.
Okay. Okay, now you can have your iPad. Be careful, you're welcome.
Hi, Nini.
Hello, Nini.
Hi, Nini. My name's Mallory. It's so wonderful to
Mallory.
meet you.
Hi, I'm James. I'm taller. How are you doing?
What are you guys playing?
Was you on the iPad, Mimi? Or you playing the X and O with Ollie? What you looking for? I know you're not looking for no more cookies when you ate a whole pack of it.
Stopped at a minute and 21 seconds. The boys were playing with other foster siblings they had downstairs, but they're able to come up, shake their hands, introduce themselves. They were doing very well, and it was wonderful to have the opportunity to go see them. Because of this team of people, these boys are currently able to be in society and are working their way back to where they could have been as fully functioning in society. Having autism does not mean that you need to be locked in a room or that you are useless or any less worth any other person. I can't begin to express how frustrating it is to have two children who were purposely removed from the community for such a long period of time. I would attribute a lot of this to laziness. Mr. Manke in his QP talks about how, specifically if you look at the co-actor's bedroom, there's a lot of fast food trash. And he says, you come home from work, you eat your fast food, the cups sit there, and then the next day you repeat the cycle. And it's just laziness. And as an adult, you have the ability to live however you want to. But when you are caring for children, you owe children a level of care. And the way these children were living was not only unhealthy, but severely debilitated them when they already had special needs. Parenting is a commitment to turning a child into a functioning member of society and making sure that they are happy, healthy, and prepared for life. Not only was Mr. Manke a member of this household by his own admission, he had the mental wherewithal to make sure those kids were okay. He frequently talked about how Katie had so many needs and so many mental health problems, and Mr. Manke was for sure the most high-functioning member of this household. I cannot estimate how long it'll take the boys to get back to where they should have been in line with their age group, but I am extremely hopeful having had the opportunity with Detective Pittman to go out and meet them and see how they're doing, and just to know that they can be okay one day and that the work continues with a full team of people to get them back to where they should have been. The childhood years are so important because the child's brain is developing so fast. It becomes more and more difficult to learn and retain as a child gets older. It also becomes difficult to unlearn behaviors that are deeply held by a child. Additionally, these children did have special needs, meaning they needed more support than a lot of children in our community would have needed. This was not a short-term thing. Neighbors estimate the kids had been in the house for 3 years and they hadn't seen them for about that period of time. How long the room was like that, I don't know, but it's very clear based on the state of the room that it was ongoing for a significant period of time. This was not a short period or a lapse of judgment. This was a life-altering several-year period of ongoing neglect. It was purposeful, it was obvious, and it was overwhelming. It's beyond comprehension why someone would put children through this. To be able to watch these children live like this day after day, covered in matted feces, becoming more and more disconnected from society, and unable to use the bathroom or even a fork. There aren't words for it. The co-actor in this case, upon being sentenced, told this court that she deserved punishment, and she knew it would take years for her children to recover if they ever would. The state holds an incredible amount of respect for her immediate acceptance of responsibility, and despite her very obvious and significant mental health needs, knowing that her actions or inactions were wrong. The co-actor was very upfront with her remorse and explained it in such a profound way. I think about it quite a bit. It was perhaps one of the most direct showings of acceptance of responsibility that I personally have ever heard. The state is recommending a sentence to this court's sound discretion. And I have nothing more to add. Thank you.
Thank you. Counsel, I'll hear from you.
Thank you, Judge. First and foremost, Your Honor, Mr. Manke wishes to convey and will convey himself when I'm concluded with my remarks, his remorse and his acceptance of responsibility for the conditions in the home and the emotional damage suffered by the children. I know that he was very happy to hear that they were in a good home, that they were being, that they were receiving the care that they need, and that they were making strides in terms of their development. When Katie and the children came to live with Mr. Manke, they were essentially homeless. They had been living, I think, with Katie's parents, and that was not a good situation. She had a very bad relationship with her father, and not a good relationship with her mother either. And so that was not an option for them. And so they were essentially homeless. She and Mr. Manke knew each other from high school. I know Mr. Manke's family from high school. His brother was closer to my class. And so I've known his family, and that's how they ended up contacting me when this case first was initiated. But Mr. Manke took them in to live in his home, and he thought he was doing the right thing by doing that. I think we would agree that he did the right thing. It was just simply what occurred for the next several years while they were living under his roof that made it not okay. In terms of the autism, that was never suggested to be any sort of excuse. It was more so an explanation. When the children started living with Mr. Manke, their mother explained to him that the children had autism, and that was the sort of reasoning she gave for their behavior and their lack of development. Mr. Manke does not have children of his own, and certainly did not have any understanding of how an autism diagnosis works or might affect children. And so from what he was seeing and being told that made sense to him. The condition of the home, Mr. Manke will be the first to acknowledge, was completely and totally unacceptable. It's not something that happens overnight. Before Katie and the children began living with him, he explained to me that he was by no means a neat freak, but it was, a reasonably tidied home. Certainly nothing like what the pictures show. But after Katie and the children moved in, over the course of weeks and months, the condition became gradually worse and worse. It is true that Mr. Manke would work 6, sometimes 7 days a week. He would work in industrial maintenance. He was working for Briggs & Stratton. He was paying the mortgage. He made sure that there was food in the home. As indicated by the state, the medical evaluation revealed that the children were not abused and they were well nourished. And so Manke felt at least that he was doing his part in fulfilling his role of keeping a roof over their head and keeping food in the house, and essentially, left the parenting role to Katie. He did have numerous conversations, if you want to call them that, with Katie about the fact that the children needed to be in school and that they needed to see a doctor. Katie was very, very difficult to have a rational conversation with. And so the conversation would deteriorate into her getting very upset, getting angry, and it would turn into an argument that would go on sometimes all through the night into the morning, and then Mr. Manke would go to work the next day. And so I think it just eventually became the passive lesser resistance to go to work, come home, go into the basement area, and just try to avoid any conflict with Katie. He knows now that was not the right move, that what he should have done was call the authorities. And looking back on it now, he wishes he would have. It's not that he believed that the conditions in the home were okay or acceptable, or that the children not being in school was okay or acceptable, but I don't think he understood or realized that by not taking some type of action, he himself was contributing to criminal chronic child neglect. This is, I believe, certainly a unique case for me. I spent 3 years in sensitive crimes as a DA. I've not seen a case like this or similar to this where the live-in boyfriend is charged with chronic child neglect. Certainly, I've seen the boyfriend charged with physical abuse, and we see that all the time, and there are plenty of cases that have gone up to the Court of Appeals, and those issues have been litigated. There's no question that he is a person responsible for the children's welfare as defined under the law. The legislature purposely made it extremely broad in the name of protecting children, and the rationale is totally understandable. But unlike most defendants who, if they came into court and said, I really didn't realize I was committing a crime, you would take that as not accepting responsibility. Here, I think it makes a little bit more sense. And again, it's not to say that he thought that the conditions in the home were okay or acceptable, or that the children not being in school or seeing a doctor was okay. But I think in that moment, or in those moments, he rationalized it by saying, well, I'm not the biological parent. I can't make medical appointments for them. I cannot personally enroll them in school. And so there's sort of a compartmentalization where he does his part of going to work, keeping food in the house, and the rest of it is Katie's responsibility. Now, looking back on it, he knows that he should have taken a more assertive role. And if that meant calling CPS, and if that meant the children being removed from their mother, I think as we've all seen, that was far better for them than having them continue month after month and the several years that they lived with him to be in that household. The conditions of the home were deplorable. I mean, there's no other way to put it. There's no way to try to rationalize that or explain that or excuse that. But again, Manke certainly was aware that the conditions of the home were completely unacceptable. I don't think he was spending a lot of time going in and out of the bedroom not as much as Katie was, but it certainly was obvious just being in the household that this is completely unacceptable. And he should have done more, and he wishes he would have done more. The latch on the door, there's a lot of discussion of that. That latch was on the door when Mr. Manke bought the house. It was there by the prior owner. It's not accurate to depict it as a situation where the children are being, essentially held captive in the bedroom. It was more so, they would, if they got out of the bedroom, if Katie was not paying attention or if it was late at night, they would just kind of get into things that would potentially harm them. Of course, the irony being kept in the house was extremely harmful to them as well. So there's not really much of a justification there, but that's the reasoning or rationale behind it. It wasn't to hold them captive in their minds, at least in that time period. It was keeping them from getting into things that might physically hurt them. The children, after the police were called on this particular date, the children were placed for a period of time with Mr. Manke's parents, who have been, they've come to all the court appearances and they've been in the back of the courtroom. And, they tried their best to provide care for the children for the couple of weeks that they had them, but it was too much. They could not care for them. They had not cared for small children in many years, and they were just completely overwhelmed by it. And so, despite trying their best, they advised CPS that they just would not be able to provide the children the care that they needed. They couldn't get them to keep their clothes on. They, much of the behavior that was described when they first came to live with their current placement situation was consistent with how they behaved with Mr. Manke's parents, but they did try. And I know that they're very pleased to know that the children are in a much better home, capable of caring for them. And again, it's a unique case, Judge, where I don't think anyone would say that Mr. Manke, in general, is any sort of a danger to the community. He certainly would not intentionally harm a child, or any other person for that matter. He doesn't have anything in his background that would suggest that. He overcame his own drug issues that he experienced, which is indicative of the prior OWIs that he had. And I know he's very proud of that he's been sober now for several years. He did suffer the loss of a brother that the court read about in the character letters, who died from a drug overdose. He's always been a very hard worker. He's worked in the industrial maintenance field and has achieved a number of different certifications. There's a long list of different certifications that he's achieved in industrial maintenance. So, he's been a productive and hardworking member of the community for many years. And I don't believe that he is someone that is prone to cause anyone harm. But, through this process in this case, he, has certainly come to grips with just how, just the impact of his lack of action had on these children. And by doing so, he contributed to the emotional damage that they suffered. And I know that eats at him a great deal. He did care for the children. While he did not take on a very direct or assertive parental role, he at least was there as a trusted adult that the children, viewed as a stepfather, figure, and trusted him. And it makes it all the more reason why, he wishes that he would have taken action sooner, before the police were called. In terms of the litigation in this case, Judge, there were issues that were litigated. Those issues, in my view, were appropriate issues to raise. The litigation primarily was prompted by really just kind of a communication breakdown between the parties, and once that communication resumed, Mr. Manke very quickly advised everyone that he was resolving the case. He advised the children's court that was handling the Bellows motion. and very promptly after that took responsibility. So it was not an effort to try to, get out of taking any sort of responsibility, but he felt that he had no choice given kind of where the discussions were at that time. But bottom line, judges, he feels terrible for his role in this. He feels terrible for the situation that the children were in under his roof. That was not his intention when he took them in. He thought he was doing the right thing. He thought he was keeping them safe and giving them a place to go, rather than turning them away. I would note that the biological father of the children would drop off some cash here and there, but aside from that, really had no involvement whatsoever in the children's lives. And when the CPS went and talked to him after the children were in custody, he just had he expressed no interest or willingness to take the children in. And maybe he just felt that he wasn't capable of doing it. That would certainly be understandable, but from everything I've seen, he had literally no involvement in the children's lives whatsoever. And so it's a difficult situation. I know for Mr. Manke, for his family, again, they thought they were doing the right thing, but again, as things progressed and deteriorated over time, you almost become desensitized to it in some ways because you're just trying to get to the next day and to the next week and the next paycheck. And so you sort of look past some of these things when you're living in that environment every single day. But obviously the children suffered as a result. Your Honor, in terms of the sentence, it's very hard to, fashion an appropriate sentence for such a unique case and such a unique set of facts. Given Mr. Manke, again, I don't believe poses any sort of general threat to the community. There was no physical abuse, and there were efforts to make sure that the children had food and shelter. I do think that if the court considers probation first, I don't think it would unduly depreciate the seriousness of the offense just because of Mr. Manke's role in this case. Certainly the court has options in terms of condition time that's at the court's disposal, but I think a sentence of probation in this case for several years, perhaps with imposing stay time, would be appropriate to have Mr. Manke address any lingering needs that he may have in terms of substance abuse reliance, make sure that he's continuing to maintain his continuing employment. He actually lost his job as a result of this case, and so with the uncertainty of the case going on, would have to re-engage with finding employment. But with his resume and his experience, he's already had a number of companies reach out to him to see if he was available. And so that certainly is an option. And he would be living with his parents and would follow all the rules of probation if the court were to consider that. And so, Your Honor, that would be our recommendation. He does have 5 days credit, and I believe Mr. Manke has a brief statement he would like to read to the court.
Very good. Thank you. Mr. Manke, now is your opportunity to talk with the court and tell me whatever it is you'd like me to know.
Okay. Well, first off, after going through the situation that happened last year, I realized I didn't handle things as well as I should have. I see now that I was wrong in not of contacting the proper authorities like the police or CPS for help to give the children a better living environment than what was at my house and what they had at my house. I am truly sorry that the boys' living environment was awful, and I feel bad that I wasn't able to keep up with the cleanliness of the house. I am very happy to hear that the boys are with a new caring and loving family. I see now that the living situation that they were in was not a healthy living environment for the boys at all. And I really wish, looking back, I would have done something about it earlier. If I were to have known that the current living situation was illegal and wrong for me, and that I'd be facing, serious charges and potential jail time, I would have done things completely different in my life. I do understand that not knowing that I should have reported the whole situation earlier doesn't make what happened okay or justified in a way. I just ask the courts for forgiveness as well as forgiveness from the boys, and that I am happy that they are thriving now and doing better than when they were with me and living at my house.
Thank you. All right. We're here today for sentencing. Nothing further, defense?
No, Your Honor, thank you.
Very good, thank you. All right, so the state has complied with notice provisions, so we can move forward with the sentencing today. There is no written victim impact statement or a request for restitution that's been filed with the court. Restitution will be set at 0. As I indicated, I have 4 letters that have been filed with the court by counsel for Mr. Manke on his behalf. I have a letter from his cousin Katie, C-A-T-I-E, who writes to attest to his character, has known Mr. Manke for his entire life. And points out that Mr. Manke is a kind, honest, and giving man. I have a letter from Judy Finn, F-I-H-N, Mr. Manke's aunt. She indicates that Mr. Manke is very smart, loving, and caring, that he's always there to help. Talks about Mr. Manke's younger brother, Danny, who passed away, according to this letter, passed away 8 years ago, where Mr. Manke discovered him and tried to revive him. But ultimately, he did pass away. Mr. Manke, I'm sorry for your and your family's loss in that regard. Points out that Mr. Manke is a hard worker and always trying to help people in any way he can. I have a letter from Matt Finn, same spelling of the last name, Mr. Manke's older cousin, who's known him his entire life, indicates that Mr. Manke is remorseful about some of the things that have happened, and that Mr. Manke wound up in over his head in this current situation, which was a challenging set of circumstances, and mistakes were made, but that the situation spiraled out of control. Points out that Mr. Manke, or that they think that Mr. Manke has learned some lessons through this ordeal and would avoid the situation entirely if he had to do it all over again. And I have a letter from Carol Murawski, M-U-R-A-W-S-K-I, who talks about Mr. Manke, points out that he's extremely bright with limitless potential, and discusses the current circumstances, talks about this brother that passed away as well. It's interesting, one letter indicates that this person died from a heart attack. This letter indicates this person died from a seizure. Counsel indicates this person had a drug overdose. I don't know. What is clear is that this loss of a person in Mr. Manke's brother is something that is a significant tragedy for this family and for Mr. Manke personally and the circumstances surrounding it. Again, the court is sorry for the loss that the family has suffered in that regard. I don't know what to make of Ms. Murawski's comments about her neighbor in Texas and what's going on there, so I won't comment on that further. And ask this court to consider giving Mr. Manke probation and community service similar to the request of defense counsel on his behalf by way of sentencing recommendation. I'm grateful for these letters and the insight it provides me into Mr. Manke and his circumstances. I've also been provided with a packet of photographs and have been shown video. I have presided over multiple motion hearings over the course of this particular case. And I understand the basis for that and the reasons for that, and that's fine. So the court is very aware of the circumstances and the body-worn camera footage. And I recall that the photographs refresh the court's recollection in that regard. I had not yet seen that footage from January of this year that depicted both of the boys. And I'm sure everybody in this courtroom shares this court's sincere gratitude that they are doing as well as they are. Coming up to shake an adult's hand, as any person would want a kiddo of that age to do, especially in this day and age of phones and kids not knowing how to answer the phone or any of those things because they're used to texting. And people hope that their children learn how to have these appropriate interactions with other adults. And it is so nice to see that. These two young men acting in this way, because this court remembers the circumstances of their escape in July of 2023, which brings me to the case before the court. There are three factors this court addresses at sentencing. First is the nature and gravity of the offense. Second is the character and background of Mr. Manke. And third is the need to protect the public. I'll address all of them in turn. As I've commented on the letters surrounding Mr. Manke and his background, I'll just comment further on his character and background here. He has pled guilty and accepted responsibility to chronic neglect of these children over at least a year time frame, resulting in emotional damage. He has prior criminal convictions, but nothing of this sort. There is prior criminal convictions for a drug offense, possession of a controlled substance without a valid prescription, and 2 operating while intoxicated offenses that the court is aware. They are all about 10 years old and point to prior issue with substance use or abuse. I would note that it appears that at least some of the medications that Mr. Manke is prescribed to help continue with maintenance of sobriety and counsel, I don't want to assume that's accurate, correct?
That is.
Okay. And counsel does indicate on behalf of Mr. Manke that he's had years of sobriety now, and that is a good thing. So it doesn't appear to be as though there was some sort of ongoing drug issue that led to the circumstances that happened back in January of 2023. No sort of issues that were present as it appears there may have been 10 years ago. Given what has been presented here, I know Mr. Manke has a 12-year high school education plus additional years at WCTC. Is that the technical college out in Waukesha?
Yes.
All right, thank you. And I presume that all relates to your skilled employment in industrial maintenance. I know that you were working at the time of the events when this was discovered back in July of 2023. Working sometimes 6 or 7 days a week, providing for the payment of rent at the residence everyone was residing at, as well as food and those things that would be necessary for nourishment of the children, and you as well as Ms. Koch, I presume. You have pled guilty and accepted responsibility. You've addressed the court in the letter that you have. The nature and gravity of the offense. This circumstance that was discovered in July of 2023, and I use the word discovered because by all accounts, this was an ongoing situation in the home that these 2 children, CJ and DJ, were made to endure. they escaped that day. And they emerged from the residence by breaking a window. That by all accounts had been boarded up by Mr. Manke himself in order to both soundproof the interior of that bedroom from the exterior of the residence, but also to block the neighbors from seeing in and to prevent people from getting out. That would be the natural and probable consequence of doing what it is that was done. These windows, and it was all of the windows in the room, were boarded up with soundproofing material, cookie sheets, and plywood. It's clear from the pictures now that the state points it out, but there are washers that are present on the plywood that was on the windows. There is a picture that I'm looking at now that has part of the perhaps cardboard torn and taken away, but there is plywood at the bottom. That is one window. There's another window that is broken, and you can see the cookie sheets, the foam type of material that was in the windows, and the broken glass. I understand these children, after being evaluated and cleared by medical professionals, it was determined that while they were incredibly dirty, their hair so matted with feces and filth that they needed to be shaved. Their bodies so covered in dirt and other things that it was impossible to believe that these children had been regularly bathed, if at all. But they were not physically abused. While there may have been bruises on them, the state indicates, and I have no reason to doubt, that all of the bruises that they had were typical bruises that a child would have from childhood play or whatever. There were cuts or blood present on one or both of the children, but that is attributed to their escape from the room, from the broken glass in the window they needed to climb through. They emerged from the residence on July 13th of 2023 into the city streets of Milwaukee, beautiful sunny day, and I'm thinking now of the body camera footage and the interviews of both eyewitnesses who stayed on the scene to talk with police, as well as interviews with the co-actor and Mr. Manke after he came back to the residence. By all accounts, when the children escaped, Mr. Manke was at work, and the co-actor was home. He was contacted, and he did come home. But this was a beautiful summer day. Kids were playing in the street. The neighbors were out, as evidenced by the amount of people that both witnessed the children when they escaped and were walking naked in the street, and I think they may have been diapered, but in any event, certainly a sight completely not in keeping with the street that these children were on. And I say that because the state has said something that I think deserves to be reflected on. This is a normal community in Milwaukee County where these kids could have played with neighbors, played with other kids in the street, at least have been out getting fresh air, things like that. They weren't. They were confined and imprisoned in the home. And the complaint states at least a year period. I know the time frame that's been discussed during the sentencing has been the time frame from when the children moved into Mr. Manke's home, when they and the co-actor moved in about 3 years before this was discovered. And 'Cause it's sad what these children had right outside their doorstep that they were kept from for so long. It was discovered what was going on in the home. Ms. Koch showed law enforcement the interior of the residence. They saw the conditions of the room. They saw the broken window that the boys escaped from. They saw the room that is completely covered in all parts by dirt and feces. It's almost beyond description, the room that these two children were confined in. I say confined because of the doorknob cover on the door, the latch on the exterior of the door, but most importantly, the windows that were boarded up and covered to prevent their discovery and escape by Mr. Manke himself, by no one other than him. It's not indicated that the co-actor did that, boarded up the windows, soundproofed the windows. It's indicated that Mr. Manke did that. And the parents of the world should be at ease. It's okay to use doorknob covers. It's fine to use things of that nature in order to childproof a home. This was not childproofing a home or a space for children that needed that in order to be safe in the course of normal parenting. This was confinement in a room covered in filth and chronic neglect that resulted in these children being deprived of normal human interactions, childhood experiences, and things that would provide them the nourishment, because it comes from things other than food, that going to school, being in society, and interacting with people can give you. These children were confined to solitary confinement with a tablet and a TV in a room that was completely unkempt. And it's very sad. And I think everyone acknowledges how sad it is, and everyone is very, very grateful for the resilience these children have shown and the strides they've been able to make while outside of the home. I would note that much have been indicated of Mr. Manke and the role that he took in the home. I understand, Mr. Manke, that you worked and saw that as a large part of how you contributed to the household, and there's no doubt that you did. The court is not convinced that you did not have a direct parental relationship. I know you're not biologically the father of the boys, but there was a relationship here between these children and yourself, as evidenced by the body-worn camera and one of the children clinging to you when the law enforcement officers were investigating the scene. And you holding that child and providing comfort to that child. It is clear that this child saw you in some sort of a caregiving capacity, or the adult in the room that could have done something. And that was sadly squandered because I think by all accounts, there was an ability to keep the residents clean. The rest of the residents, except for one room, which I'll get to in a minute, the rest of the residence is very cluttered. There are items and garbage and things throughout. It is a home that does not have bare surfaces where one could organize things or keep things clean. There is what appears to be an empty dish drying rack with items that are clean and perhaps clean, but drying in the dish drying rack like you would see in any typical home that hand washes dishes, right? Like there's some things in the utensil tray, and there are some items in the sink in the kitchen. So it appears as though there was some dishwashing happening. There is one side of the two basin sink, for lack of a better term. It's a, kitchen sink with a divider in the middle. One side has what looks to be dishes that are ready to be cleaned. Another side looks as though is much less full, and I can see what looks to be a clean sink basin with clean or clear water standing, so it looks like somebody's recently done the dishes. There's another room that's completely covered in items and things. It almost looks as though portions of the kitchen may have been used and maintained, and other portions of the residence may have been used to stockpile items, pile up items, let them rise to the level of table height and things underneath the table and on top of the table. I mean, this place was full, but it looks like perhaps there's spaces carved out of the piles so that people can move about the residence. There is the room in the upstairs of the residence that's inhabited by Mr. Manke and the co-actor. The floor is pretty dirty, and there's cups that are full and cans that may be empty or full from McDonald's and other takeaway places from the food that Mr. Manke and/or Ms. Koch would come home with, consume, and then set down on the counter and walk away from. That was their room. There is a lot of dirty things, including what looks like a diaper on the floor. Stacks of those cardboard takeaway trays for drinks. It looks like there's at least 50 piled up neatly. And there is, and it's not contained within these photographs, I don't think, that are provided to me, but I remember it from the body-worn camera, the bathroom. The bathroom of the residence, which I understand Mr. Manke was the person who was responsible for maintaining, was immaculate. It was bright, it was white, it was shiny, it was clean. Ms. Co-actor was very proud to show officers when she did the consent search of the residence with them that there was running water and a clean bathroom in this residence, to show them this. I point this out because there's this sink in the kitchen and there's this very clean bathroom, and Mr. Manke, who is going out into society and working 6-7 days a week in a skilled profession, that shows that there is some ability to both have a neat and tidy home where you want it, and not in other places. There's photographs of DJ and CJ from the time that they were discovered when they escaped. Again, they both had longer hair, but the hair is so teased out and big from being unbrushed, at least for CJ. DJ's appears to be maybe pulled back or something into a pony of some fashion, but it's matted. You can see the mats, they're visible. You can see the filth covering CJ. You can see the cuts from his escape. The conditions within which these children were confined were deplorable and almost without description. Mr. Manke did maintain portions of the home, did maintain work for a significant period of time, and as evidenced by the letters from his care, the people who care about him and his family, was able to conform his life and his behavior to the outside world just fine, that no one would know or even guess at what was going on within the home. It's the combination of the circumstances of the room of the boys, the absolutely horrendous circumstances that they were made to exist in and were confined in, with an exterior latch on the door, a doorknob cover, themselves, or that this was all a piece of some sort of appropriate parenting plan. This was two boys that needed the adults in their life to do better, and they locked them up and threw away the key, for the lack of a better term. At least Mr. Manke did. He walked away and left them in that place every day and went to work. And I know that much has been said about how if he would have recognized the circumstances around him, if, to use his words, he would have known that he could have potentially gone to jail for the circumstances, that he would have done something completely different. And people have said repeatedly, calling police or calling Child Protective Services. You know, it doesn't have to get to this point and then you call police. It can be asking the neighbors for help, or calling the school and saying, you know, there's these kids that are in my home. I'm not responsible for them, but I think that they do need some help, and what resources are there in my community? It's not that you need to lock away these kids, let it get to this extent, and then, well, gee, today maybe I should call the police because this is really backwards, what's going on here. This is a community that we live in where we have resources for children and people that care about kids. And I don't mean to say that Mr. Manke or the co-actor didn't care about the kids. I think that they did in some way, but the care that was provided here was horrendous and absolutely rises to the level of the criminal charges that have been brought and that Mr. Manke has pled guilty to. It never had to get to this point, as I guess the thing that I want to indicate in particular, after hearing from your lawyer, Mr. Manke, about the circumstances of bringing the co-actor into the home, the children, wanting to provide them something, the circumstances of what the co-actor said when she was interviewed by police and talking about how she didn't want to give up the stability that she and the children had living in the residence. It's sad that these circumstances were something that was so good from her perspective that she didn't want to lose it, because this was really bad. The circumstances these children were removed from were really bad. And I think that everybody can acknowledge that. So these children were in your residence. They were there for a period of time, Mr. Manke, and you, through your neglect of them and chronic neglect of them, did cause them to suffer damage as a result, emotional damage as articulated by the statute. And I think that that's best supported through what we've heard about the boys at the time of their discovery, and what's occurred since then. So by all accounts, these boys have autism. I think they were formally diagnosed with that. But as to how much of that circumstance is attributed to the underlying autistic issue and where it is they are on the spectrum as it relates to that, and how much of it is as a result of being confined for a significant period of time in a room covered in feces and filth and separated from society for as long as they were, and how much that impacted their ability to grow and become the young men that they are growing up to be. As I indicated before, there's so much more to nourishing a child than just feeding a child. And part of that is exposure to the world, school, friends, family, etc. I understand at the time that these children were discovered that they were not potty trained. They had major issues. They had issues even being outside. The professionals that were attempting to evaluate them had to do so in different circumstances than they otherwise would, given their aversion to being in a confined space. They were ultimately placed in the home where they now reside. The update from October of 2023, so some months after their discovery in July of 2023, they're now using the toilet. They're starting to listen. They're following directions. They're in school and able to do well in school. And they're even liking walks and being outdoors. The update from January of 2024, they're now writing some words. They're spending the whole day at school. So this is, 6 months from being, go ahead, State.
The January update, we just went to see them, so it was 25.
Thank you for that. I appreciate that. So January of 2025. So they're spending the whole day in school after a year and a half after their escape. Accurate?
Yes.
Thank you. And so this would be in keeping with the footage that was shown here in court today. They can sit through a movie at a movie theater. They've gone to an amusement park. They can go shopping. They're able to be and interact in society essentially like any normal kid. I mean, they do have some issues, obviously. They've got a diagnosis of autism, but there are lots of children with diagnosis of autism that go to school, do well, have friends, go to birthday parties, graduate high school, get married, have families, all sorts of things. I mean, it's not a diagnosis, and in particular for these kids, that means that they should be confined and put on a shelf and ignored. They're doing much better now. The state indicated, and this court agrees, and I think the legislature reflects that in the code here regarding child neglect, that adults owe children a level of care. Those adults that are privileged to be people responsible for their welfare and get to live with them and be with them. These boys deserved that. They deserved to be nurtured in more ways than being fed and provided with opportunities to be in the community. These boys deserved and needed maybe even more care than your typical day-to-day child, and certainly not the circumstances and the life-altering neglect that they were made to endure. As it relates to the need to protect the public, I think that is clear on its face. Children deserve to be nurtured and loved in their homes and not confined in a room and made to endure the living circumstances that these boys were for the amount of time that they were. Again, it's hard to overstate the level of filth and disarray that they were living in on a day-to-day basis. It's unthinkable. It's unthinkable what they were made to endure. Their diagnosis is not an excuse, and counsel acknowledges that, but uses it by way of an explanation about some of the things, including the latches on the doors, which I understand were there when you bought the residence, so pre-existing the boys coming there. But again, it's not one thing on its own. It's the totality of the circumstances and the absolute disarray of the room that they were confined to. And in particular, the boarding up and soundproofing of the windows. And Mr. Manke acknowledged that, discussed it in his Miranda's interview. As indicated in the complaint, he stated he knew how the DJ and CJ were living was not right, but he had to, quote, pick his battles, end quote, with the co-actor in order to avoid arguments. He stated he never contact police or schools to report the children because he doesn't believe in doing that to family members. Instead, he left them behind and went to work every day. I think our community is deeply invested in children in our community. People want kids in our community to grow up in safe and loving and happy homes so they can be safe and happy adults and in their interactions with people. By all accounts, CJ and DJ are doing well now because of the care that they are receiving outside of your home, Mr. Manke. Mr. Manke, coming back to you, again, you're 40 years old. Your prior criminal convictions are dated and substance related. You have a high school education and technical college education to help you attain the level of employment that you've been able to obtain in the community and maintain. I understand you've lost your job as a result of this case, but you were skilled in industrial maintenance and had that employment previously. You've been sober for years. Drug issues are not what were underlying this. And your lack of action and turning your back on these children has resulted in emotional damage. You've directly talked with the court. You acknowledge you didn't handle things as well as you should have. You say you should have called police or child protective services. Again, things did not have to unravel to this point. You certainly could have reached out to individuals long before. Instead of boarding up the windows and soundproofing the place, you could have talked with those neighbors or reached out for help and indicated that you need the resources or somebody needs to come and help. And you never did. You indicate you're truly sorry and that you feel bad you weren't able to keep up with the cleanliness of the home. You were able to keep up with some of it. But again, the room that these children were confined to was not a room that just got kind of cluttered. It's not even cluttered to the point of the rest of the residents, which is cluttered to the point of being of hoarding type of behavior. I mean, there is a significant amount of items in the rooms. The room that the boys were in was filthy and infested. You acknowledge the home was healthy. Looking back, you wish we would have done something earlier. You didn't do anything but come home when it was discovered. I mean, you've acknowledged your responsibility and pled guilty here today. But in saying that you wish you would have done something earlier, you did nothing to stop this. The only reason why this ended for these boys was that they escaped. And and the people having their day on July 13th saw them escape and called police. And if you knew it was illegal and you could potentially go to jail, that you would have done something completely different. You have pled guilty and accepted responsibility. You've resolved the matter short of trial. Those are, I think, the things that the court has here for the court's consideration here today. So what to do? Probation is to be considered first. Its purpose is to rehabilitate and protect society without placing a person in custody. The state leaves sentence to the court's sound discretion. Counsel urges the court to adopt a term of probation, perhaps with some upfront condition time, imposing and staying a sentence, and points out that you, sir, have spent 5 days in custody during the course of this prosecution. Probation is not appropriate. It would unduly depreciate the seriousness of this offense if probation were granted. I know that the court needs to consider it first. The court does consider it and does find that a probationary sentence would unduly depreciate the seriousness of this offense, the totality of the circumstances, and Mr. Manke's culpability as it relates to what it is these children endured. That is not to say that rehabilitation is not important. In every sentence that the court renders, the court addresses the 4 things it tries to achieve. That is first and foremost rehabilitation, because that is how the court believes that we can achieve lasting and meaningful protection of our community in a long-term sense. I understand that you were functioning in society, sober, maintaining, and doing well by all accounts, except for what was behind closed doors in your residence. I don't know what probation can do to rehabilitate you from circumstances that were existing at the time these events were discovered. It certainly could seek to support and maintain those things. And rehabilitation will be part of the sentence, of course, because that long-term protection of the community is only established by that goal. Short-term protection of the community and indeed punishment of you, Mr. Manke, and deterrence of you and anybody else who may wish to engage in this behavior will be met by the term of confinement that this court will sentence you to in this matter. But again, first and foremost in any sentence the court gives is that rehabilitation. And so on extended supervision, Mr. Manke, I would like for you to maintain absolute sobriety. I would like for you to continue to engage in, well, have an alcohol and other drug assessment. It appears as though you're in recovery or aftercare support.
I go to a, for previous drug addiction, I go to a clinic once a month. I have drug tests every month. I have to have, you know, the prescriptions I'm taking in my system, nothing else in my system.
Yeah.
And I also did Justice Point with no issues for a complete year.
Right.
So, yeah,
Right.
it's not a problem.
Wonderful.
You know,
Okay.
going to get a drug and alcohol assessment.
Wonderful. So what I was saying, and thank you for supplementing and telling me those things, Mr. Manke, that's also my impression of where you were with your substance abuse treatment. That is, I understand you're in an aftercare and recovery support sort of environment, right?
Yes.
Like you're maintaining this medication to keep you sober. You've been sober for a while and you're doing the things in order to maintain that. I'd like that assessment just to ensure that's where you are, and then you should cooperate with any aftercare or any treatment it is that may be recommended. You should continue to take your medications for any mental health diagnoses also. You should have a mental health evaluation and cooperate with treatment. But I know that you're in and engaged with the treatment team now, so perhaps signing releases for whatever it is that you're engaged in, so that can be maintained. And cooperate with any other treatment and counseling programs is determined by your agent. I would like for you to pay the DNA surcharge as to the count to which you have pled guilty. There's no request for a restitution. Restitution will be set at 0, given the acceptance of responsibility and the nature of this court sentence that the court is going to hand down today. I will waive the other costs and fees that I can for you as it's associated with this prosecution, but the mandatory costs and fees are due in full during the term of extended supervision. One moment. Pardon the pause. Thank you. All right. Very good. So having discussed the terms and conditions of extended supervision, Mr. Manke, I need to advise you of a number of things. First, you have been convicted of a felony offense in this matter. You may not possess a firearm in the future. If you possess a firearm in the future, it's punishable with a maximum possible penalty of a $25,000 fine or 10 years in prison or both. You cannot vote until your civil rights are restored. And counsel, you'll file that paperwork as well, the notice. Thank you.
Yes.
And you also need to provide a DNA sample as a result of these convictions if you haven't already done so. So the court has considered a variety of factors here today as outlined on this record. The court has considered but rejected the option of probation, as again, I do believe it would unduly depreciate the seriousness of the offense. The state, or excuse me, this court is obligated to impose the least restrictive sentence given the circumstances. I would note Mr. Manke has pled guilty to 2 Class E felonies, both of which hold a maximum possible penalty of 15 years each. The chronic neglect that these children suffered is something that is outlined by the court here is almost unthinkable in its extent and the environment that they were subjected to, the length of time that this was ongoing, and the impact that it had on these boys. I have considered the acceptance of responsibility, the dated nature of the past criminal history. I have considered your acceptance of responsibility. I've balanced it with your culpability in this case, as well as your direct actions that you've taken in confining these children. I would note the false imprisonment is read in, so the court may consider it. And having balanced all of these factors and everything I've indicated here on the record, I sentence you as follows, Mr. Manke. Count 7, 10 years of prison, bifurcated as 5 years initial confinement, followed by 5 years of extended supervision. Count 8, 10 years in the Wisconsin prison system, bifurcated as 5 years initial confinement, followed by 5 years of extended supervision. I would note that this is significantly less than the maximum possible penalties for the offenses for which you have pled guilty. Count 7 is consecutive to count 8. Count 8 is consecutive to count 7. I will give you 5 days of time and credit for time you spend in custody pretrial as it relates to count 7. You are not eligible for the challenge incarceration program or the substance abuse program. Your substance use issues are in remediation and certainly not a circumstance that was interfering with your ability to conform yourself to the conduct of the law at the time these circumstances were discovered. I don't believe earned release is appropriate given the circumstances that I've addressed here on the record, and I am rejecting it. You should serve each day in custody as initial confinement for what it is that you've engaged in and the lack of care you provided to these children. This is a final order of the court. You have the right to appeal this decision. Your lawyer will talk to you about your appellate rights and help you pursue an appeal if it is something that you want to do. The most important thing you need to know about that is this, sir. You need to start that process within the next 20 days if you wish to seek an appeal. State, have I missed anything?
Nothing from the state.
Counsel, anything I should correct or clarify on this record, please?
Your Honor, I just want to clarify, the court's running the 2 counts consecutive to each other. Correct.
Anything else, counsel?
Would the court consider the substance abuse program?
No. Again, I think each day as initial confinement is appropriate for what it is these children were subjected to and what it is these children endured. And so I don't think it's appropriate. I don't. But thank you for the opportunity to clarify that. Anything else, counsel?
No, Your Honor.
Very good. Thank you. That's all I have.
Thanks.
Like me? Didn't I get them in a kit and I just throw them in the trash?
We'll address it then. Yeah, it's fine.
Oh, yeah, here. This.